Welcome to Part 6 of our video series on detailed reading of the Digital Personal Data Protection Act, 2023. Please check the Part 1 to get an overview of the various chapters in the DPDP Act, Part 2 for detailed review of Chapter 1, Part 3 for detailed review of Chapter 2, Part 4 for detailed review of Chapter 3, and Part 4 for detailed review of Chapter 4. In this video, we'll be reviewing Chapter 5 of the Act, covering its key sections and compliance structure. As discussed in the Part 1 video, the DPDP Act 2023 is organized into 9 comprehensive chapters, and scope of this video is Chapter 5, referred to as Data Protection Board of India by the Act. Chapter 5 covers 9 total sections, from Section 18 to 26. Key provisions include a 2-year tenure for members, eligibility for reappointment, a 1-year cooling-off period, and 5 disqualification grounds. The board members are also considered public servants. Section 18 outlines the establishment of board. Subsection 1 says the central government, through notification, appoints the Data Protection Board of India. Per subsection 2, the board is a body corporate with perpetual succession, a common seal, and the power to acquire, hold, and dispose of property, and to sue or be sued. Its headquarters will be at a location notified by the central government, as provided by subsection 3. Section 19 details the composition and qualifications for the chairperson and members. Per subsection 1, the central government will notify about the chairperson and number of members of the board. Per subsection 2, chairperson and the members of the board are appointed by the central government. Per subsection 3, they must be persons of ability, integrity, and standing, possessing special knowledge or practical experience in fields like data governance, law, and digital economy. At least one member must be an expert in the field of law. Section 20 is about salary, allowances payable to, and term of office. Per subsection 1, these terms are as prescribed and cannot be varied to the disadvantage of the chairperson or members after appointment. As per subsection 2, they are appointed for 2 years and can be reappointed. Section 21 is regarding the disqualification for appointment and continuation as chairperson and member. Subsection 1 lists the disqualification grounds for a chairperson or member, including being insolvent, convicted of an offense involving moral turpitude, physically or mentally incapable, having a prejudicial financial interest, or abusing their position. As prescribed by subsection 2, removal by the central government requires providing an opportunity of being heard. Section 22 covers resignation by members and filling of vacancies. Per subsection 1, members can resign by written notice, which is effective when the central government permits relinquishing office, after 3 months, or upon a successor entering office. Vacancies are filled by fresh appointments, as given in subsection 2. Continuing with Section 22, as per subsection 3, the chairperson or any other member shall not accept any employment for a period of 1 year after ceasing office, except with previous government approval. They must also disclose subsequent employment with any data fiduciary against whom proceedings were initiated before them. Section 23 addresses the board's proceedings. As given in subsection 1, the board must observe a prescribed procedure for conducting business and authenticating its instruments. Subsection 2 says, no act or proceeding is invalid due to any vacancy, defect in constitution or appointment, or procedural irregularity that doesn't affect the case's merits. As per subsection 3, the senior-most member discharges the chairperson's functions if the chairperson is unable to do so. Section 24, on officers and employees of the board. It states that the board may, with previous central government approval, appoint officers and employees necessary for its functions on prescribed terms and conditions of service. Section 25 is about members and officers as public servants. It mandates that the chairperson, members, officers, and employees of the board are deemed public servants under Section 21 of the Indian Penal Code when acting in pursuance of the Act's provisions. Section 26 is regarding the powers of the chairperson. It lists out the powers, including general superintendence and giving direction on administrative matters. The chairperson can authorize officers to scrutinize correspondence and authorize the performance or conduct of any board functions and allocate proceedings among members. We recommend the CalPI Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to the raw reading of the DPDP Act. Hope you now know more about the chapters of DPDP Act. This was the 10th video in this series released by DPDPAmentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, DPDPAmentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.